Good afternoon. Welcome to today's webinar, the Dodd-Frank Wall Street Reform and Consumer Protection Act, the impact on regulatory mandates and securities litigation. During today's webinar, our presenter will cover the following: an overview of the Dodd-Frank Wall Street Reform and Consumer Protection Act, how your legal practice might change under the new legislation. Is it revolutionary or evolutionary? The whistleblower provision, the statute of limitations, arbitration protocol, and the U.S. legislation compared to reforms in other countries. Today's webinar will feature Louis Straney. Louis has extensive experience in senior level management in financial services. Currently, he serves as a consulting and testifying expert in securities litigation for both plaintiff and defense clients. He is the author of 2 texts on securities fraud, one of which is used for training and certifying of fraud examiners. His most recent book, Securities Fraud, Detection, Prevention, and Control, will be released by John Wiley & Sons in November of 2010. If you have a question that pertains to this presentation, we do ask that you use the chat or Q&A feature, which are found here on the right-hand side of the screen. Louis will do his best to answer your questions during the 2 Q&A breaks that we will be taking during the presentation. Tomorrow morning, I will send out an email with a link to the archived recording of this webinar, and I do ask that you take time to fill out the survey that will appear on your screen after the webinar is over. With that said, I now invite you to sit back, relax, and enjoy. I'm now going to turn it over to our distinguished presenter, Louis Straney. Louis, it's all yours.
Thanks, Matt, and good afternoon to everyone. We have someone from Hawaii or Alaska, so good morning to you folks, and I look forward to going through this with you today. I will tell you that I've done this a time or two, so I'm not experimenting, and I encouraged everyone in the previous presentations to email or contact me with any questions, and I will also encourage you to do the same. This was a real monumental task. There were about 2,300 pages related to this legislation. I've actually read it all, believe it or not, stacks and stacks of paper. There's probably some things that I missed and probably some things that are important to you. So I'll try to cover all that I can during this 1 hour. I'm going to be respectful of your time, and we're going to try to keep it as compact and as fast-paced as we possibly can. The slide presentation was designed to be printer-friendly, so there's not a lot of color. I try to keep it to a minimal just so you can see some of the contrast. And with that, I'll probably move forward. I used a sort of a subtext here in the beginning, how much reform and how much protection, because I think that's very important to consider as we go through this, because this legislation was given a lot of media coverage during the process, but is faded from the front page since then, as a lot of legislation does. So I think that as we move through this, it's very important to keep in mind that this was targeting reform, targeting consumer protection, and at the end of the day, I'll leave it up to you to decide how much of that's been accomplished. Here's the way the bill actually looked. It looks more important because of the Old English style font that was used in preparing the text. Again, it's 2,300 pages, and I'm asking myself, and I think you'll be asking yourself too, is how much reform and how much protection.
Excuse me, Louis. Could you just, I guess, speak a little closer to the speaker, a little louder? Some of the audience is having a problem hearing.
Okay. Is this better?
That's a lot better, yes.
Okay. I'm sorry. I'm on a hotel speakerphone, so I apologize. I'm going to turn the volume up on my side a little bit, Matt.
Okay.
How's that?
That's perfect.
Okay. Very good. I'm sorry. I'm glad you interrupted. This legislation was signed into law by President Obama on the 21st day of July of this year. Here are some of the highlights from this. Really, it's the first major reform since the 1930s. In my opinion, we've had Sarbanes-Oxley, which was targeted towards the WorldCom and Enron, but again, this is sweeping reform in my judgment, and it's the first reform on a major scale since the 1930s. It is not retroactive, so it's not reaching back and correcting things that have happened in the past. It really is forward-thinking. It is reaction to both scandals and some rascals that we all are probably pretty familiar with. There was a lot of partisan bickering when it came right down to it. The vote was strictly along party lines. It is reacting to some of these events, partially to the large-scale bailout and to derivative trading. There's been no shortage of comments in the press. They've faded recently, but I'm going to give you some of the comments that I think are pretty interesting. And here's probably the most important comment from President Obama. He was talking about the consumer side of things, highlighting the consumer watchdog and Americans being duped into things that they didn't understand. And that was published in the New York Times in July, just before he signed it. Here's some other comments, and certainly in support of the bill. Facing down Wall Street. I'm not going to read them all to you. Certainly targeting the excesses on Wall Street. Fixing financial flaws. Milestone. Curb the freewheeling culture. Certainly the toughest financial reform since the Great Depression. Responsibility and accountability, you're going to see a lot of that throughout this bill and some of that through this presentation. And at the end of it, they just didn't want to drive all the derivative business out of New York. Here's some of the counterpoints to that. It's called toothless measures. No facts actually speak for themselves. Targeting some of the people that got wealthy during this period of time, it really doesn't address the way that they were treated. And then I like the last one. It's kind of interesting. The result of a 2,300-page legislative monster before us that expands the scope and power of ineffective bureaucracies. I think former Federal Reserve Chairman Paul Volcker put it interestingly and probably very pragmatically. As he and President Obama first discussed this, it probably had certainly more substance to it. But as he commented here, the act went from what is best to what could be passed, and I think that's fairly common in the political circles. Since this is the first legislation since the 1930s, I'd like to take a snapshot view of what this country was like in the 1930s, and our security laws, certainly the 33 and the 34 Acts, were based upon a country that's very different from today. So let's take a look at some of the things that this nation looked like in the 1930s. The population was just under 130 million. The average annual salary was under $1,400 a year. Probably of all the things that I have done during this presentation for other groups, I've heard back from so many people saying that they had no idea that the salary was that low. Milk was 14 cents a quart, bread was 19 cents a loaf, and steak was 42 cents a pound, so very different conditions than we have today. This is slide number 9, which is a very important slide in my opinion, because each of you will have your own agenda, your own interest, and this is going to help you sort through the various sections of this monstrous document, and I'll just put them all up. And I will tell you that nearly the first half of Dodd-Frank is definitions, structure, and just general comments. When you really get down to the substance of it, it's going to be sections 8 throughout the end. So if you're trying to find something, now the documents that are available online for you to review are PDF searchable. So you can go in and if you, for example, you're interested in statute of limitations, or if you're interested in fiduciary duties. If you're interested in clearing arrangements, you can use that as a keyword search. But I will assure you that the first half of this is primarily definitions and saying that we're not going to let things happen like they happened before. You really get up to some substance when you get to Section 9 and then throughout the rest of it. So this is going to be a slide that's probably going to give you some guidance as you look at how this might impact your practice. And then that wraps that up. And Section 1256, if we have any folks here that are involved in forensic accounting or accounting, the 1256 contracts could be important to you. So Section 9 through 16, in my opinion, are the primary sections to begin with. Again, this is a slide that might help you sort through this monstrous document. Here's a keyword search. As I mentioned, this is a PDF file, and you can take a look at some of the things that were important to the policymakers as they drafted this. These are the number of pages these terms are found on. I thought it was interesting. Aviation, even though it's hard to imagine why aviation would be mentioned in this bill, was found on 3 pages. The elderly was only found on 3 pages. So in this document, aviation was given equal weighting to the elderly. Subprime, one of the certainly foundation issues that have concerned people for some time during the financial crisis, was only found on 2 pages in this 2,300-page document. Capital market, really the key to all of this was only found on 2 pages. Structured products, in an area that many of you are familiar with, has been a problem for investors for the last 3 or 4 years, was only found on 2 pages. Prospectus, which is to the heart of full disclosure, was never mentioned in the document whatsoever. New York, arguably the site of all financial services for this country, was only mentioned on one page. Chicago, where most of the derivatives in this country are traded, was never mentioned. Alaska was given the same weight as New York, and come to find out, Guam was given 5 pages for it. So in the wisdom of drafting this document, Guam was far more important than New York, Chicago. And then honesty, which I think should be at the heart of this, was never mentioned whatsoever. Here's some things that were discussed, debated, but left out. And I think it's important to see not only what was in the document and in the legislation, but is missing from the legislation. The final status of Fannie Mae and Freddie Mac was not decided by Dodd-Frank, which had been the intention of many. So the government remains the largest mortgage lender in this nation. The fiduciary requirements of all financial advisors, unlike Canada, which imposes fiduciary requirements on all advisors, we have not reached that stage yet, and we'll talk about that just a little bit later. But fiduciary requirements, it is something that is being investigated, or is instructed to be investigated through the bill, but certainly is not in the legislation at this point. And toughest restrictions on derivatives trading. There are some restrictions on derivatives trading, but certainly not as tough as originally discussed. And then finally, the elimination of compulsory arbitration. That was one of the highlights that was discussed early in the debate, but is missing in the final act. The SEC is required to conduct a study. The results of that study probably won't be known for a couple of years, but it is not in the final act either. Here's some highlights. I think it's important. We have a watchdog bureau. There's lots of bureaus, commissions, agencies, you name it. There's a lot of bureaucracy surrounding the new Dodd-Frank Act. So we have a new watchdog bureau. There's going to be a challenge of the too big to fail. It's going to be difficult to fall under that protection now as a financial services company. The financial crisis monitoring systems are going to be enhanced, and we'll talk a little bit about that later. The disclosure requirements are going to be enhanced for exotic investments. Shareholders are going to have a voice in executive compensation. I'm not sure how that is different from the system now, but I do know that they will have access to proxy materials, which I think is not the case now. Oversight of the credit rating services, which will fall under the SEC, which is certainly a new issue for all of us. It strengthens, in general, all the oversight, and it formalizes a whistleblower system, which has gotten a lot of people excited, but I will discuss that later. There's certainly some reasons to doubt whether or not that's going to be as effective as people might imagine. Here's the new watchdog bureau. Let's talk about that. I've abbreviated it to CFPB, Consumer Finance Protection Bureau. It's an independent part of the Federal Reserve System. It has a $500 million standalone budget. I think that from what I understand from some contacts in government, it's already starting to be staffed up. It will be pulling from a lot of different organizations, including the SEC, probably FINRA, maybe even the IRS and the FBI. Broad authority. And this is interesting, too, is that the new CFPB will not have to ask Congress to make new laws. Under the guidelines and the mandates given to the CFPB, it can manage by rules. Now, certainly the rules cannot be in conflict with some broad-based constitutional issues, but from what I understand is that they'll be able to set new guidelines without going to Congress for approval. We're going to have a new Office of Financial Literacy, and this is going to be a very powerful, by any measure, powerful new bureau. Here were the candidates. When I first did this, there were 3 candidates, and after the initial appointment of Ms. Warren, I still left them up there because I think it's an interesting list of very qualified people. Michael Barr, Eugene Kimmelman, and then Elizabeth Warren, as most of you know, who really was a leading advocate and working with President Obama to establish the CFPB. She has been named the interim head. She is, because of the structure of her appointment, she does not have to be approved, so there's not going to be a political controversy at this point because she is named as an interim director. Many of you probably have read her books about consumer credit. I think they're probably indicative of some of the things that you might expect from her going forward in terms of consumer advocacy. I found some interesting quotes from Ms. Warren. I'm going to give those to you. And here's the challenge that we face with anything that's run out of Washington. Is that I use a Chinese proverb that I found, I think kind of speaks to this. I see it's running off of my screen, so I'll read it to you. It says, the mountains are high and the emperor is far away. So in order to accomplish some of the things that they'd like to accomplish through Dodd-Frank, people are going to have to understand that the mountains are high and the emperor is very far away. Here's some of the quotes from Ms. Warren. I thought it was interesting. If you've seen her interview, this is right out of her, from her lips to God's ears, the way she feels about some of these things. She is going to be very direct, and that's probably one of the reasons they didn't at this time want to face Senate confirmation because of her directness. But she certainly is not going to be someone who's going to see this as a bureaucratic job and an executive position. She's obviously going to roll her sleeves up and get started right away. But here's one of the issues that she faces. I've been watching polls like this for a very long time, for my entire career. I don't think I can recall a time when the general confidence in financial institutions has been so low. This was a study that was conducted by the Associated Press and the National Constitutional Center poll of just over 1,000 adults. I'll explain it to you because it's a sort of inversely intuitive here. The not too confident and not confident at all starts with the small and local business, which people have the highest level of confidence in. And then it works its way up to banks and financial firms. 52% of those polled were not too confident or not confident at all in banks and financial firms. Slightly beat Congress, but not by very much, and then blogs and citizens media as well. So people are very skeptical at this point. There's going to be a lot of show me how this works as we move forward. And again, it just highlights the fact that Congress, who constructed this bill, and the target of the bill, banks and financial institutions, are really kind of at the end of the list. Okay, Matt, I think that we should be either taking questions or taking a pause here for me.
Yeah, we're going to open it up now for questions. So if you have any questions for Louis, please use the chat feature, which is found here on the right-hand side of the screen. We've had some questions come in during the presentation, and I wanted to pose those to kind of get it going, but please, we are going to take a little break here for questions, so please do submit your questions if you have them for Louis. Louis, we have a question here that comes from Carol, who asks, the legislation is extremely broad-based. How do you suggest that a fraud examiner, auditor, regulator, or enforcement professional get their bearings and know how to take advantage of the opportunity, and what should they be looking for?
Well, certainly I think that there's 2 or 3 levels of opportunity here. I think that you have, for your individual practice, if you have a proprietary business and you're operating a small business, I think that there's going to be a learning process, a teaching process, if you will. And I think that one of the things that comes to mind is that you want to become, I think, the go-to person for the discussions of how this might impact some of your existing clients, not to mention the clients that you could expand to. So I think that in looking at that slide 9, there's going to be an acronym that we look at a little later on called TRACE that will talk about some of the issues that you can use as well to help your current customers and clients in focusing on the areas that might be more relevant to them. For expansion, I've already seen law firms beginning to advertise that they want to represent whistleblowers. I mean, it's pretty prevalent in the PR market right now to see firms going out and saying that we'd like to be your partner in bringing up these issues, and we'll discuss that a little bit later. So I think for law firms, there's certainly the possibility of representing whistleblowers. I think in terms of what you do to get ready for it, I think you're going to have to understand derivatives, because if there's derivative transactions within the company that you're auditing or you're working with, you're really going to have to sharpen your skill set in derivatives, the clearing of derivatives, reporting of derivatives, and the financial impact of derivatives, because that's going to certainly be an area where there's going to be a lot to do. But fortunately, that this will not take statutory effect until the summer, I think July 21st of 2011, so you're going to have some time to work on it. But I'd probably, if I were sitting in most of your seats at your desk, I'd start working on derivatives and make sure that you can communicate effectively with your existing and potential new clients on the requirements for derivatives.
Okay, great. Thank you. We did have a request. If you can try to speak up a little bit, you're fading in and out at some point. So could you just give an audio test real fast and try to speak a little closer to the speaker?
Okay, how's that, Matt?
That's a lot better.
Okay, yeah. Hold my face a little closer to it.
Yeah. We have a second question here from Jim, who asks, how long do you believe it will take before the financial services industry and this kind of follows up on what you just said. How long do you think it will take before the financial services industry and enforcement professionals start to address the issues related to the mandates in the legislation?
Well, I think that from what I understand, they're getting started today as we speak. As I mentioned earlier, the July 21, 2011 is the official switchover, but it's like Y2K. You can't wait until the first day of the new year to switch your computers over and start working on the new software. Firms, from what I understand, are already working on this and already starting to organize themselves and starting to communicate within their various business units to find the topical hotspots where they really need to focus. So I think they're doing it today, Matt.
Okay, great. And one more question from Jen, who asked, do you think that Dodd-Frank is strictly a North American initiative, or what will the global impact be on some of the other jurisdictions of the financial markets?
I'm glad you brought it up because I've been following the Canadian market for some time, and I think the Canadian, and there's a clause in there related to conflict minerals, even though it's an esoteric area for many of the people on this call, including me. But because Canada is such a large mineral and mining country with a lot of trade between the U.S. and Canada, there's a clause in the new Dodd-Frank related to conflict minerals. So there's going to be more, it is really targeting Africa and especially South Africa, but it really targets areas where there's armed conflict to make sure that in some way we're not contributing to armed conflict or terrorist groups through that. But the Canadians are very concerned about it because it's going to require some of these smaller businesses that are mining and mineral concerns to have full disclosure of all the parties involved and make sure that they're not in some way in conflict with that clause on mining and mineral companies. So it's going to affect Canadian companies, and I'm already seeing those companies discuss that, and certainly it's going to affect South Africa and probably Indonesia as well. So it's adding a new element of safeguards where the U.S. is not going to be involved in conflict minerals and not going to be involved in any business that includes graft, embezzlement in any way, or financing terrorism. So there's some interesting aspects to this.
Okay, great. I don't see any other questions in the queue, so we could probably continue on with the presentation of content. We will be taking another question and answer break, so if any attendee has a question for Louis, please feel free to use the chat or Q&A feature to submit that, and we'll get it answered as quickly as possible. Thanks.
Okay, I broke the sections down into the most important sections that I could determine, and again, I'm not using any outside third party. These are the things that certainly came to mind as I looked through the legislation. So I want to start with mortgage reform. Unlike some of the problems that we've had in the past where lenders would simply issue mortgages without documents and without qualifying buyers and then sell those mortgages off, not holding them, and certainly contribute to our financial crisis here in this country. Under Dodd-Frank, it's going to require lenders to ensure that borrowers can repay. So I think the no-doc sort of loans are going to go by the wayside. You're going to have to prove that you can repay the loan, and it's going to be required that the lender have all levels of assurance that you can repay the loan. I think that, as Ms. Warren said, that she's going to eliminate some of the language that was unclear. She's going to make it very straightforward in terms of what you're going to be paying. If it's an adjustable rate, I think it's going to, in many cases, eliminate, in certain markets, eliminate adjustable rate loans. But it should be right straight up front under the new legislation of what you're paying and when you'll pay it. And then there's going to be under HUD an Office of Housing Counseling. I think that you'll see throughout this a lot of measures that are trying to keep people in their homes, both writing checks, houses of counseling, and other ombudsman sort of figures within these organizations to help people keep their homes. Hedge funds. Certainly if you're working with hedge funds, there are going to be some new rules. They've been, as I called it here, the paradox of oversight, because sometimes they were FINRA regulated, sometimes they were looked at by the SEC, but sometimes it was a gray area and really nobody looked at them. But now they're going to have to report to the SEC. And interesting element, and if you work with any state agencies, I think the state securities and insurance commissions, and they're known by different monikers in every state, but all of a sudden the hedge funds now are going to be under anything under 100 million, where it was under 30 million before, are going to be regulated by the state. So those departments are going to really have to ramp up, and especially in the Northeast. If you're in the New York, New Jersey, Connecticut area where there's a lot of smaller hedge funds, they're going to be under state regulation now if they're under 100 million. There's issues related to minority and women inclusion. This has been overlooked, but I think these are important measures. I think very positive measures related to Dodd-Frank. You're going to have an Office of Minority and Women Inclusion. It's going to target employment and contracting opportunities for this target audience. And then there's going to be technical assistance and probably financial assistance as well. Too big to fail. They're trying to eliminate this term from the vocabulary of Washington. I'm not sure we've reached that point yet, but here's their attempt to do it. And there's several elements to this, and so we'll call this one Part 1. The options for the liquidation of financial institution have to be prepared in advance. So it's like writing your own funeral. You have to write your own liquidation the way that the company should be sliced and diced in the event that it failed. The new capital and leverage reserve requirements basically are saying that they're not going to get less. They're going to be where they are or even higher. And the commentators have said that this eliminates the possibility of another 2008 TARP-like bailout. I don't believe that's true. I think that it lessens the likelihood of it, but there's nothing to keep the government from stepping in and doing another 2008 TARP bailout. It just discourages it, but I don't think it eliminates it, not from my reading of it. And the financial firms are going to be required to make the deposits into this fund for bailouts or for near bailouts, so the federal government's not going to have to do it. And I think they're targeting $50 billion from the financial institutions to begin with, so it's a significant amount of money. Let's look at this again. The Volcker Rule, Paul Volcker certainly had a lot of sway in designing some of the elements of Dodd-Frank, and he wants to keep bring back some elements of the old Glass-Steagall, where we isolate the high-risk trading investment sponsorship away from the commercial side of the bank. The FDIC limits are not going to be expanded under Dodd-Frank. That had been lobbied for because of the lack of coverage for some of the Madoff and Stanford victims, but the FDIC coverage is not going to be expanded. And then, again, you're going to have to write your own funeral plan. Here's what Wall Street has thought about the new legislation. I like to follow some of the indices that kind of speaks in terms of what the market feels about it. This is an index, an exchange-traded fund that's based upon bank stocks, the KBE, and you can see the performance over the last several months. The red arrow indicates when the bill was signed, and the bank index has actually gone up in value. I checked it this morning, still right around 24. So Wall Street investors, professional investors, don't believe that this is going to be a crippling blow to financial services. Here's the Oversight Council. This is one thing that I haven't seen much press on, and I think it's an interesting element, and we're probably going to hear some strong voices come out of this. This new Oversight Council is going to have 10 financial regulators. One is going to be independent member and 5 non-voting. It's going to be chaired by the Treasury Secretary. they're supposed to be looking on a global basis around the world in terms of things that could be putting stress on our financial system or putting systemic danger in their path. So there's not going to be a lot of wiggle room, as I mentioned here, for existing banks. In effect, if you're a bank, you have to remain a bank. You can't switch back and forth between a bank and a broker-dealer in order to sort of game the system for capital requirements and restrictions. The capital requirements are not going to be lower than current levels. And this is going to be, this new Crisis Oversight Council is going to be a public agency where the reports are made public and that they will have to appear before Congress, I think, on an annual basis and report. Here's required disclosures. I thought this was an interesting thing. It's something that I've complained about for a long time. The SEC and the CFTC are going to have to settle the turf war between any regulatory gaps related to over-the-counter derivatives. It's simply not going to be the case where over-the-counter derivatives are unregulated. They will have to settle that issue. This is something that I'd like to see how this is going to actually be applied, because they talk about a new clearinghouse for derivatives that can be cleared. So as you imagine, if you didn't want your derivatives to be transparent and have visibility, you just make them something that cannot be cleared, maybe by adding different elements that trade on various exchanges. I don't really like the language there. I like the notion of a clearinghouse, but I don't like the notion of letting too many people off the hooks. And then any financial institution that's carrying derivatives on the books is going to have those available for regulators to oversee now. I think that those have been available in the past, but not in a unified manner. So now it's sort of codified. I mentioned this earlier, the shareholder voice and executive compensation. They get to talk, in terms of have a voice and executive pay and golden parachutes. The direct access to investor proxy, I think, is new. And interesting element here is that if a senior officer of the firm has lied, the shareholders can force it to go back and recover funds from that person over there. I think it's 5 years. So, and the SEC filings now, I think you'll see it in the 10Qs and 10Ks, will show a 5-year record of executive compensation. This is something new. I think it's something that one of the things that I'm more excited about than some of the other elements is the oversight of the rating agencies, which were often cited as part of the financial crisis. They're going to have oversight by the SEC. There's going to be an office and regular inspections. The filings are going to have to be made public. So this would cover Moody's, Fitch, Standard & Poor's, and any other rating agency. Those are the three that come to mind. And then this is a major change, and many of you may be familiar with it. This is revoking the Rule 436G on expert liability. So a rating agency now will be deemed acting in an expert capacity, and they are not excluded from liability when it comes to their rating. So they will not be able to say, don't make your investments based upon our rating. They're going to have expert liability, like a lot of folks on this call have expert liability. Here's some of the things that address that issue. It puts them in the same boat as attorneys, accountants, and engineers, expert witnesses, certainly. And you can't get off the hook because you say it's a best efforts analysis and don't rely upon it. So that is a major change. Here's my paraphrasing of what I see in the bill. It certainly is my proprietary interpretation of it, but I think we have to start someplace. And I'll just read this because I think it's very important. Now the expert has liability unless it can be demonstrated that after reasonable investigation, the expert had grounds to believe and did believe that the opinions and statements were true and all material facts required for the representations were not misleading and nothing of a material nature was omitted. So that's my understanding of the hurdle that experts will have in terms of liability under Dodd-Frank. Here's how it strengthens the existing financial regulations. Again, it's not looking back, it's looking forward. It strengthens the Volcker Rule by keeping 3% of the bank's Tier 1 capital to hedge funds. I'm not sure how this is going to work. I'd like to see this really drawn out, but at least in writing it sounds good, but on a practical basis I'd like to see how they're going to do that and keep those special purpose entities and special purpose vehicles not going beyond the 3%. The Office of Thrift Supervision, which has been around as long as I think I've been in the financial services, is being abolished, and those offices are being moved over to the Comptroller of the Currency. And bank subsidiaries now have the same guidelines as the holding company, which is a big change for all of us, I think. Insurance. This is interesting as well. We have a federal insurance office is now going to be part of the Treasury Department, and it's going to monitor systemic risk, not only in the U.S. but on a global basis. So they're going to be looking at if there's an AIG in England or an AIG in Russia, they're going to want to know about it and how it might affect our insurance business. And then the final element is that it's going to attempt, and there's a lot of great insurance commissions in the states, and I think that the initiative to beef up the coordination between the federal and state projects is a real important element of Dodd-Frank. Consumer safety nets and advocacy. This is probably one of the things that a lot of investors are interested in. Banks are no longer prohibited from paying interest on business demand deposits. There's going to be oversight of the credit card interchange fees for small businesses. And then this is an interesting one that I've gotten some comments on, is that consumers will have free access to any credit card information that impacts their employment opportunity. So if they apply for a job and because they have a bad credit report, that's the only thing holding them back from that job, they get free access to that information to see if there's corrections that can be made. Part 2. As I mentioned earlier, this is probably one of the things that many of us are interested in to see how this develops. SEC has a responsibility to determine if brokers and financial advisors should be deemed fiduciaries. That's the way it is in Canada. So we'll see what's going to happen with the SEC's analysis of that situation. Currently, as you know, it's really fiduciary status is limited to trust departments, discretionary accounts, registered investment advisors. And for those of you who are not familiar with the difference between our system and where we deem an advisor to be a fiduciary, it really does put the client's interest first instead of being a reasonable recommendation or reasonable service. And I'd like to just give you an example of that, how that might work, reasonable and suitable versus a possibility of someone's best interest in a fiduciary capacity. So I use the analogy of someone who wants to buy a coat. Under our current system, it's reasonable and suitable if someone wants to buy a coat, you've represented it properly to sell them the coat. You have no other requirements beyond that. But in best interest, much like in a fiduciary capacity, you can say, yeah, you like the coat, it fits you, it's just like I described it, but since you have 200, I'm not going to sell you any more. That's the difference. And that's not where we are, but that's where some other countries are in terms of financial services. Consumer safety nets and advocacy, part 3. I've been a fan of the General Accountability Office. Used to be called the General Accounting Office for a long time. They do a really good job. Many of you may be familiar with a study they did several years ago in terms of the recoverability of awards through arbitration. The GAO is now going to do regular audits of the SEC. I think that's a terrific part of Dodd-Frank. There's going to be an investment advisory committee consisting of a group of investors. I can't imagine being able to keep that group quiet when they get around to talking to the SEC about their recommendations. That's going to be an interesting meeting. And then finally, there's going to be an Office of Investor Advocate in the SEC to aid investors who've had problems dealing with the SEC. So I think that many of you read David Cox's scathing criticism of the SEC when he did the Madoff audit. It was just, it was unmercifully candid and direct. And so I think that that's going to be institutionalized at the SEC now. Here's some additional safety nets, and let's look at those very quickly because we're about to run out of time. They're saying that anybody that sells mortgage-backed securities, many of you have extensive experience with MBS securities. They have to retain 5% of the credit risk. They don't say how long. I would have liked for them to have identified how long they're going to have to retain that, because I was talking with someone who originates and designs these things, and he said, yeah, we'll retain them, but we'll sell them out the next day. So I'd like to see that quantified a little bit better. There's going to be enhanced documentation for the underlying assets. I don't know what enhanced means when you have some of these structured products that have 500 different types of securities. I don't know how you can have enhanced documentation, but I'd like to see what that means. And now the municipal bond advisors are going to fall under SEC. In the past, they've been under the Municipal Rulemaking Board, so MSRB, so now that's going to fall under the SEC. The safety nets and advocacy, mortgage relief, as I mentioned earlier, there were some direct financial aspects to Dodd-Frank for mortgage relief. $1 billion going to states and municipalities. It's a lot of money to help avoid foreclosures. $1 billion in mortgage relief for the unemployed. And then a HUD legal assistance program to help homeowners facing foreclosure. Again, these are important elements and not often discussed related to Dodd-Frank. I think Dodd-Frank has been sort of painted as Wall Street reform, but there's some significant consumer protection measures embedded in this as well. Global issues. Here's some of the things that I talked about earlier. Oil, gas, mineral fees paid to foreign persons or partners is basically targeting bribes. State Department is going to be involved in developing a policy so there's no link between conflict minerals and areas where there's armed conflict. And we want to make sure that funds going into through the International Monetary Funds are going to the right places, and they're going to limit it to countries that have sustainability and not where the debt exceeds the gross national product of the country. Whistleblower. This is probably the thing that has been talked about more than any other aspect of Dodd-Frank. I think it's like the bounty hunter of this legislation. So let's take a look at what it means. The program is under the direction of the SEC. There was a whistleblower aspect to Sarbanes-Oxley, but now it has expanded. It's under the direction of the SEC. Encourages people to report securities violations. If there is more than $1 million has been recovered, rewards up to 30% of the recovered funds. And it must be material, actionable, and it must be of substance when it's reported, not just I heard at a cocktail party or this or that. And here's probably the most important thing to many of you on this call is any whistleblower must be represented by an attorney. I can see some issues related to that. There's not a lot of attorneys that want to finance and commit to a long-term battle against a large corporation. So I think it's a mixed blessing. It certainly recognizes the importance of a whistleblower, but also in identifying that they must be represented by outside counsel is going to potentially pose a burden for both the whistleblower and any legal counsel that they may choose. What's in it for me? Here's this sort of the accompanying slide to slide number 9 when I broke it down. I think there's obvious employment investigating career opportunities, flat out. This is creating a new, larger, and broadly based bureaucracy that's going to need to be staffed both internally and with consultants. Experts are going to come under increased scrutiny to the point that truly they will have to be experts or will have liability. There's going to be systems needs, both software and internal compliance systems going to have to be designed and monitored, and then the legal representation for whistleblowers. So I think those 4 bullet points are very important to think about in terms of your own practice or your own business. And I think as we end up getting close to the end of the presentation, here is sort of point, counterpoint. The point is that Dodd-Frank enables, the critics say it must mandate and not just enable. It underscores positive behavior. Other folks will say that it underscores weakness. It's pointing to new staffing, but largely existing staffing with tired and ineffective habits. It identifies many independent advocates, but how independent will they actually be? Major shift in tone, the supporters say, but tweaks and really not a major shift in tone. Widespread support, widespread doubts. Self-funding aspects. Obviously, some of those costs are going to be passed on to consumers, and I'll talk about that in just a minute. In a quote from Jamie Dimon at Chase, who says that if you can't charge for soda, then you'll charge more for the burger. So any additional costs to financial services firms kind of throws out the whole notion of self-insuring. Those costs are going to be passed on to consumers. There's certainly no doubt about that. Okay, here's some of the things that I would encourage you to link up with slide 9 and the various sections. I'll just get these up there very quickly. I like to have acronyms. It helps me remember things. So TRACE, you're going to have within your practice, within your client relationships, there's going to be a requirement for more transparency, certainly responsibility, accountability, consumer protection is going to be an ongoing initiative. It's not going to be solved immediately. And then embarrassment. We never want to have the embarrassment of bailouts again. So TRACE, link it up with slide number 9, the different elements, and consider how that might be effective for your practice or your business. Sort of the political comment on this is shifting. I thought this was interesting. I found this in the New York Times recently, that in January of 2008, 70% of the political donations from securities firms went to the Democrats, who obviously are the main sponsors and architects of the Dodd-Frank legislation. However, 18 months later, nearly that same amount is going to the Republicans, who are the primary opponents of the Dodd-Frank legislation. And Senator Chris Dodd made this comment, and I think this is a good way to close. We don't know the full results of what we have done until the very institutions we have created, the regulations we have suggested and provided for, are actually tested. So we're in a gearing up phase. It really gets underway in July of 2011, and it's probably going to be another 12 months or more after that until we really see what's going to develop. So with that, I think that Matt, I'll open it up for any final questions or any comments. And I will assure you that I put my email address and my phone number up there and my website to encourage you to ask questions or to follow up with comments. So I truly believe that. So with that, Matt, I'll turn it back over to you.
Okay, great. Louis, thank you for a tremendous presentation. We do have a couple questions that have come in, and I would encourage those in attendance to keep on submitting the great questions. As you noted in your presentation, there's been a lot of commentary on the whistleblower provision of the Dodd-Frank Act. But as you see it, did the Dodd-Frank, or as you see it, and as you think forward, do you think the Dodd-Frank Act will eliminate most of the obstacles that whistleblowers now face?
No, not at all. I think one of the obstacles they face is getting fired, and I think they still have considerable risk within their organization, either from getting fired or less direct problems. No, it's not going to eliminate it, and it's still, you're still an outsider, and it can be a long, costly, and unsuccessful experience. So no, it's not going to. It's going to reward you if you're successful, but it doesn't eliminate many of the hurdles.
Okay, great. We have another question here who they ask, and I think it's in regard to a slide that you put up a little while ago that talks about the new limits of $100 million for funds that will now fall under new state regulation. What do you think the biggest challenge is with the new state and federal securities and investment regulations that are out there, and how will it affect how firms operate?
I think that initially, and this is a fairly meat and potatoes kind of analysis, Matt, is that I think staffing, training, and budget issues for a state, and many of the states are stretched now in terms of both personnel and budgets. So to say all of a sudden you have twice as many registered investment advisors or hedge funds to audit and to investigate can be a tremendous burden for a lot of these states, especially the smaller states that are having other issues. If I, just thinking out loud here, if I think about the state of Michigan, I know there's a lot of registered investment advisors there. The unemployment rate's high, the state revenues are down. I think from a staffing, training, and budgetary perspective, this is going to present a real problem.
Okay, great. We have another question here that deals with, I guess, a recent news item. It talks about the banks halting some of the foreclosures, or putting a stop to their foreclosures for a set period of time. How do you believe do any of the provisions in the Dodd-Frank Act talk about that, and do you think there will be amendments or something that deals with the recent string of news that we've had about foreclosures in America?
Well, I don't find any language in there related to it except the language where there's going to be funds provided for unemployed or facing foreclosure, the ombudsman departments and agencies to help out. So I think that what happened was that there was a question about procedures and proper documentations and representations made by the banks. They stopped the foreclosures, and then in the last day or so, I've seen that they have now started them back up again. So I think now that they've probably instituted changes where they're in compliance with it. So no, I think the foreclosures are going to continue. Now, from the news, it appears that they've slowed down some, just because already getting a lot of those things out into the market and coming to some solution. But no, I think that the people that were facing foreclosure 6 months ago are going to be facing it again within the next few weeks.
Okay, great. I don't see any more questions in the queue, so I believe we're going to wrap things up here. On behalf of TASA and everybody in attendance, I want to thank Louis for a great presentation. It really it showed that you put a lot of effort into it and a great amount of research, and we do thank you for taking the time to read all 2,300 pages of the legislation so you could put this presentation together. If you would like to speak to Louis about a case or project that you have, you can contact us here at TASA. The number is 800-523-2319. We will be sending out a link to the archive recording of this webinar tomorrow morning. And the archive recording will also be posted in the Knowledge Center of TASA's website. That's where we post all of our past webinars. If you have any follow-up questions or comments, please email me at mhyde@tasanet.com. We do take all your comments, and we try to make our programs better based on the comments that you supply. So I do encourage you to take the time to shoot me an email. We do have a couple more webinars coming up. We have one on October 21st and one on November 4th. Please look for an invitation in your inbox shortly. And we hope to see you at future TASA events. Thank you so much for your time.